Start the webinar with my comments. That's it. I'm just starting introducing. That's all, right?
We are live.
Okay. The webinar with my comments. That's it.
Now,
I'm just starting introducing. That's all, right?
We are live. Yeah.
Okay. Okay.
I'm going to start.
I can start. Hello and welcome to the webinar to discuss. I'm sorry. Okay.
It's okay. Go ahead.
Then I think Abhi has to tell me when you're ready to.
Yes, go ahead, please.
Go ahead.
Yeah, Puneet, you can go ahead.
Okay. Hello and welcome to the webinar to discuss the implications of the recent UK Supreme Court judgment on the issue of unseaworthiness in case of CMA-CGM Libra, organized by the Institute of Chartered Shipbrokers Hong Kong branch and co-organized by IMU Indian Maritime University, LMA London Maritime Arbitrators Association, HKMAG Hong Kong Maritime Arbitration Group, and SCMA Singapore Chamber of Maritime Arbitration. I'm Puneet Oza, the Executive Director of Singapore Chamber of Maritime Arbitration, and I welcome you to this webinar. While I'm currently involved in maritime arbitration and now have legal qualifications, I am at heart still a commercial shipping professional, having worked with ship owners, charterers, and brokers for over 25 years. I still remember the first time I came across terms such as seaworthiness, due diligence, Higgsby rules. They were all literally Greek to me. I would say a lot of maritime professionals would still struggle to fully understand the legal implications of these terms and how they operate in a shipping contract. However, we have the fabulous legal systems across the globe and a great system of law in common law, which actually gives an amazing insight on legal key concepts through precedents and cases. And in case where the highest court of land hands down a judgment, they simplify and explain concepts in the best possible and most useful manner. CMA-CGM Libra judgment of UK Supreme Court is another such judgment. In pre-COVID days, if we were confused about such terms, we would end up talking to our seniors or P&I clubs or in-house legal counsels to clarify. One of the positive side effects of COVID is the accessibility to these webinars, where still our experts from across the world, like the panel we have today, can actually present, explain, and clarify the key concepts of such an important judgment. I'm really thankful to ICS Hong Kong for organizing and taking lead on this. I'm also very happy to see 3 of leading maritime arbitration centers of the world, London, Singapore, and Hong Kong, all coming together with Indian Maritime University as well for this event. This is a great example of collaborating to spread knowledge and awareness. We have an amazing panel comprising of lawyers, arbitrators, in-house counsels, and commercial shipping professionals. I'm really looking forward to hearing their views, and I cannot think of a better person than Mr. Jagmeet Makkar to moderate this panel. Jagmeet is the chairman of the Hong Kong branch of Institute of Chartered Shipbrokers, IMEI chair at the Indian Maritime University, and one of the Asian ambassadors for the Baltic Expert Witness Association. He sits on the board of Global Met and on the advisory board of GMAC under Gujarat Maritime University. He's a practicing maritime arbitrator and sits on the panel and lists on a number of arbitration bodies, including SCMA, CMAC, LMA, HKMAG, and HKIAC. Jagmeet, over to you. Thank you.
Thank you very much. Thank you, Puneet, for these kind words and fantastic introduction to the webinar. And welcome to all the participants and the panelists once again. This is indeed a very important decision, and there are different views with regards to its implications. From what I understand, one view is that the decision is based on specific facts of the case, this particular case, and it does not, in general, dilute the navigation defense provided to the carrier under the Higgsby rules. While some other views are quite different, they are possibly pessimistic from owner's perspective. I would like the detailed discussion to our experts, and I'm going to introduce them very briefly. Michael Allen. Mike is a chartered marine engineer and a former solicitor. He is an LMAA arbitrator as a full member. Jay Sharma. Jay is partner and head of Cargo Casualty Clyde & Co. LLP. Amanda Hastings is legal counsel, solicitor England and Wales, working in Western Bulk. Mikkel Hen is the barrister of the legal firm 20 Essex. Edward Liu. He is the partner of Hill Dickinson LLP based in Hong Kong. And the session chair today is Mr. Clive Eston, the past president of LMAA. A warm welcome to all our panelists and all the audience. What could be better than asking our panelists to just give their own ideas in their own words for next, say, 4 or 5 minutes each. How do they see this particular decision? And in their opinion, what could be the broader implications? So let's start with Mike. Mike, what do you think? Or why don't we start with Jay first? I think let's have the legal perspective. All right, Jay.
Thank you, Jagmeet. So hello everyone, and thank you for joining us for this webinar. So as mentioned, I'm Jai Sharma from Clyde & Co, and we acted for the cargo interests in the CMA-CGM Libra, defending the general average claim. So, I mean, how to summarize a 10-year project in a few minutes? I'll try my best. It started off as a relatively unremarkable grounding. Luckily, there was no death or injury, there was no pollution, no wreck removal. In fact, the grounding was on sand and the vessel was able to continue the voyage. So far, so boring, you might say. GA was declared and we defended that for our clients from that point until the recent decision from the Supreme Court, I think on the 10th of November this year. Now, although this decision has attracted a lot of interest and was, as far as we're aware, the first time passage planning has been considered in the context of a dispute between ship and cargo, in our view, broadly speaking, it maintains the status quo in terms of the principles of seaworthiness and due diligence. Now, to my mind, the decision clarifies the error of navigation defence only applies once the voyage has commenced. It does underline the fact that this was a case about seaworthiness rather than the error of navigation defence, and any deficiency arising from a failure to exercise due diligence will potentially render a vessel unseaworthy if it was present before the voyage commenced. It may also act as a showcase for the point that due diligence is a test that evolves with the times to reflect evolving technology, evolving expectations, and perhaps an environment of greater accountability. I think it will be interesting to see how often in practice it's found to be a cause of the casualty. Also, bearing in mind from an English law perspective, it only has to be a cause or one of the cause and not the sole or dominant cause for cargo to succeed either in defending general average claims or indeed recovering other losses after a casualty such as this. So I think those, to my mind, are the key points. I would caveat that. It's a strong caveat. You know, we're looking at this case at Clyde & Co from a cargo perspective, and we understand that that's just one side of the story, one point of view. So I think that summarizes my initial thoughts, and I'm happy to hand over to Mike, I believe.
I think, Mikhail, if we can take forward the legal perspective to that.
Thank you, Jagmeet, and thank you everybody who's giving up their evenings or mornings, wherever you are, to listen to us. Broadly, I agree with what Jay is saying, is that the decision is at least couched in terms of well-recognized principles. One of the reasons perhaps the decision is more interesting than it might appear at first sight is that on the whole, there are all sorts of cases where carriers are held responsible for failures by the crew to do things. But on the whole, those crews are not then also held to be perfectly competent. So what was really interesting in this case was the question of whether carrier discharges obligation to exercise due diligence, where even though the passage plan was ultimately held to be defective by reason of the crew's negligence, the courts had also held that the ship had been competently manned and that the crew had everything it needed for the preparation of a passage plan that wasn't defective. Now, I also accept that I'm saying this from a slightly biased perspective because I was instructed only at the Supreme Court stage. So it's quite natural that for me, it was less of a 10-year journey than it was for Jay. In terms of the sort of second question, which I think Jagmeet asked, which was, well, what are the implications for the future? There are certain implications which are perhaps more pedestrian. For example, Lord Hamlin has set out what I think is an authoritative framework for the analysis and interpretation of the Hague Rules as a whole. So if one ever has a Hague Rules case, the Libra is the perfect place to start. It sets out all the relevant principles. How one interprets the Hague Rules has long been a point of some controversy. That has now been settled. They're interpreted as any other international legal convention by reference to broad and general principles. You can have regard to the travo. In considering the object and purpose of the rules, it is appropriate to have regard to the history, origin, and context. And indeed, the court held it may be appropriate to have regard to the French text of the rules because the convention was originally French, and that's the authoritative version of the convention. So all of those things, quite apart from whatever one might think about the outcome, are great for legal certainty because there is now one judgment which in a couple of paragraphs sets out the framework for analysis. And at least it seems to me from a lawyer's perspective, that is some added value. In terms of the third question, which is, well, what does this mean for passage planning and navigation more broadly? It remains to be seen how many implications this case has in practice. As I say, it is a relatively rare case where what the court holds is that there was a causative fault because the crew did something wrong, but the crew was perfectly competent. And by the way, had everything it needed to do that task. So the real points of tension actually are going to perhaps arise in cases where the obligations of seaworthiness are continuing. So in a bog standard charter party dispute, one might have a seaworthiness obligation, but that is then ameliorated by something approximating to the navigational fault defense. Now, the seaworthiness obligation continues for the duration of the charter, and so does the navigational fault defense. So this bright line between commencement of the voyage and after the commencement of the voyage isn't going to work. How one resolves that question, I don't know, that's yet to be seen. It's one of the arguments that Lord Hamlin doesn't really directly deal with, and that point has been left open. And that perhaps is actually really what the tension between those two is really going to come to the fore, because you can always say, well, the navigational defense remains for all points after the commencement of the voyage. If you have a charter party case where the commencement of the voyage is irrelevant to the allocation of risk, then that's a real question. That's a real point of tension there. So I don't think I have anything more to say at this stage, but of course, there's going to be questions later.
Thanks, Mikhail. I have a few questions out of your opening comments, but we'll come to that later. Edward, would you like to join at this time?
Yep, thank you, Jagmeet. And it is my pleasure to be part of this distinguished panel. And it's also very difficult actually for me to speak after, the very excellent lawyer who were involved in this case, and they can provide insightful views about the case implications. But from my perspective, upon reviewing the three levels decision, I think that despite the case relates to the general average contributions, I believe that everyone agrees it is equally relevant to cargo claims where the vessel's seaworthiness is called into question. And therefore for cargo claim or from the cargo claims perspective, I think one certain effect of this case is that after a casualty involving loss or damage to cargo, the documentary requests and disclosure requests will be, I think, are very likely to be expanded to involve all relevant documentation from the load port concerning the preparation of the vessel for the voyage, which I understand that our members will be elaborated further. And I think from the ship owner's perspective to defend against potential cargo claims, it needs to be more meticulous when it comes to documenting their passage planning procedure and compliance with them, including with all relevant guidance, such as IMO resolution and especially like the SOLAS. And owners will also have to ensure that this evidence trail is properly stored and preserved in hard copy and all, especially nowadays for the electronic format. Well, turning to some of the comments saying that the Supreme Court's decision, and I think the 3 levels decision in this matter appear unfavorable to vessel owners and cargo carriers. Well, I think on one side, I share the view. It is of course indeed for as lawyers, especially acting for the ship owners, more difficult to defend. But there are also crucial nuances within the judgment that, for example, as also Jackie, you mentioned, it is very factual basis, I think, the decision. And the funding is specific to that case. And also the vessel, I think the ship owners in the case, in their appeal, submitted that the Hague-Visby rules are aimed at spreading risk and allocating the cost of insurance between carriers and cargo interests. And we can see now that the Supreme Court refused to accept this submission. But on the other hand, they also pointed out that the most negligent navigation would occur during the voyage rather than before or at the commencement of the voyage, so that the main burden of resulting cargo damage or general average claims will likely continue, from my perspective, to fall on cargo interests, including their insurers, not ship owners or the P&I clubs, I think. So it appears that for this reason, I think I agree that the court decision has no significant or fundamental shift in the balance of risk between the carriers and the cargo interests. I think that's conclude my short presentation for now. Thank you.
Thank you, Edward. Thank you very much. Now coming to the real world, the chartering world, and we got Amanda from Western Bulk. Yes, Amanda, what's your view on this?
Thank you, Jagmeet. Well, first of all, I just want to say thank you to all of the other panelists and for the points they've made so far. I don't disagree with any of the points that have been made in relation to the judgment. I do want to say, from the perspective of an in-house counsel, it's a very useful judgment, just in terms of, as Mikhail raised, it provides a nice framework and as well as a good overview of the case law. In addition, if anybody hasn't read the judgment yet and you don't want to read all 47 pages, the last 2 pages have a great summary that direct you with paragraph notations to where you might want to find further reading. So if all of my textbooks at law school had been like that, it would have been way easier. But turning to the actual judgment, while the legal reasoning is very interesting to me, I'm really much more interested in how it's going to play out in practice. As we've seen with other decisions or other recent seminal decisions, say with the Vol Cafe, it has inevitably just led to an increase in work for owners and also for operators. So I think as a starting point, this will inevitably lead to more things on the master's checklist, including potential amendments to the ISM management systems and confirmations in advance of every voyage, or every time a passage plan is reviewed in advance of a voyage, even if not actually required as a result of the judgment, probably owners erring on the side of caution rather than being in a position where they've been told that, yes, you've exercised some due diligence your end, but you haven't quite done it enough to extend to your employees. I think also it's going to push owners towards looking how they can also mitigate the impact of the decision. So you're probably going to be seeing an increase in contractual indemnities. How enforceable those are would remain to be seen. from both their charterers, and also potentially a pushback on seaworthiness warranties. So you'll definitely see less owners willing to confirm absolute warranties, with some people I think even deleting most seaworthiness warranties out of their charter parties as a base, and maybe only using the incorporation of the Hague-Visby rules. And in addition to that, I think this is something I think that will be touched on a little bit further by Mike, but I think it is also needs to be taken in context of the of where we are today and the technology available now. I think the decision will result in potential changes to service contracts in ECDIS machines as well, just for sake of caution, really. But the final point I just wanted to make is what I think Edward talked about as well, is that you are going to see an increase in this decision being used in cases that aren't related to general average. It's whether or not it's being used as a legitimate tool to do with the seaworthiness point, or whether it's a delay tactic or a tactic to raise enough confusion or enough doubt as to not want to pursue it, especially for smaller matters in arbitration, will remain to be seen. But I definitely think it's going to it will lead to an increase of it at least being cited between owners and charterers. Yep. And that's all of the points I have to make for now.
Thank you. Thanks so much, Amanda. I can see in the chat box, we never had in some of the webinars that I've done in the past year, there's so much of interest and discussions going on. We got lawyers and master mariners, they're talking to each other. Now coming to Mike, with decades of experience as an arbitrator, and he's the full member at the LMA. I would like to request him, because he's the one out of all our panelists here. He's got the seaboard experience. He sailed on the ships and with an engineering frame of mind. Mike, what's your opinion on this one?
Jagmeet, thank you, and my thanks to the other panelists. I think we've got an excellent panel here. Those actually involved in the case, which is extremely useful, and those looking at what may follow on. Yes, I wear two hats here. I wear my previous seagoing experience, both deck and engine room. I learned my navigation in the classroom. I thereafter spent quite a lot of time back aft on the engineering side. But one aspect of this case is that the Supreme Court say, yes, but this was paper charts and now we have electronic charts. If you go back about 3,000, 4,000 years, the Polynesians had an ability to navigate by looking at the stars. It is absolutely remarkable, but they were able to do that. We now have aids to navigation. Radar was introduced during the Second World War. At the end of the war, it became commercially available. This was thought to be the answer to watchkeeping problems, and inevitably it led to radar-assisted collisions. The Android Stockholm is a classic example of this. We now have electronic charts, and following on from the advent of electronic charts, we have electronic chart-assisted groundings. So I think one message that comes out from this, where human error is the major cause of casualties at sea, is the training of those who are using the equipment. And it's not only the initial training, but it is continuity training that is very important, in my opinion. And also given the likely consequences of this particular judgment, how the owners are going to monitor the continuing availability, the continuing professional competence of their crews, other than simply the certificate. And this does raise the question of continuation training thereafter. In days gone by, there were shipping lines where one was part of a company and served with that company. Ben Line, Clan Line, I mean, we can all name the names, but now the position is different. I don't know what the manning of the Libra was, but it would not be uncommon for there to be a crew of 24, 7 different languages spoken, various nationalities. And once the voyage is over, the contract is finished, the individual has gone. Owners may need to look at that aspect of the competence and training of their crews, because I'm absolutely sure that the cargo interests will be concentrating on this in the future. That's all I wanted to say about the practical side. As an LMAA arbitrator, Clive and I are there to listen to the evidence. Assuming the parties weren't able to settle the case and it comes to a hearing, we listen to the evidence produced by the parties. That broadly falls into 2 categories. There are the witnesses of fact and their witness statements, and there are the expert and the experts and the experts' evidence. And just dealing with the experts, I'd just like to read you a short quote from a case. If matters arise in our law which concern other sciences, we commonly apply for the aid of that science or faculty which it concerns. Now that's rather odd language, but what it says is that the courts rely on expert evidence. It is rather odd language because it's a case called Buck and Rice Thomas from 1554. So the question of expert evidence has been very clearly with us for a very long time. In an ideal situation, if you give 2 experts the same evidence and ask them to address the same issues, they should come up with the same answer. That frequently doesn't happen. There is a strange creature called the single joint expert, where both parties appoint the same individual. I've never met the single joint expert. Parties always, for good reason, rely upon their own experts. But a part of our job as a tribunal is to come to a decision on the expert evidence itself, if the parties cannot agree. And it is quite often a matter of presentation, how they can put across complex points. When it comes to the witness evidence, undoubtedly, the earlier the statements are obtained, the better. But as tribunals, we tend to see that there are initial statements, there are then somewhat later statements that address other issues, and even later statements. As you are probably aware, the LMAA has clamped down in our 2021 rules on using witness statements to try to plead the case. There is also the independent evidence, and I'd just like to touch briefly on a judgment Mr. Nigel Chair in the High Court about 2 years ago, the Ocean Prefect. This concerned a case where the MAIB had done an investigation on an unsafe tort claim, produced a report, but one party, and the Ocean Prefect involved an arbitration, one party did not want that report to be put before the tribunal. It went before Mr. Justice Tier, and his decision was that it could not be used. And indeed, MAIB reports say at the top that they are not to be used for determining liability. They are there to learn lessons of safety, and that is absolutely right. But that did lead to a rather bizarre situation where the MAIB report is on its website. It is available to the world. The only 3 people who could not read the MAIB report were the tribunal who were determining the case. But I absolutely agree that safety is of fundamental importance, and that should not in any way fetter the MAIB or any other governmental organisation or flag state who look into the cause of casualties. I will probably pick up some other points later, but that's all I want to say at the moment. Thank you.
Thank you. Thank you so very much, Mike. I mean, it's been fantastic with regards to training and evidence, etc. I am going to jump straight to some of the questions that the audience is asking in the Q&A box. And let me ask Amanda this one. It's by Shiraz Moghul. I would ask in this matter, and looking at the judgment by the High Court and Supreme Court, what else could owner have done by way of due diligence to ensure that passage plan was adequately compiled? From my non-legal viewpoint, the owners have placed a qualified crew who, based on their certification, must legally be considered competent. How far is due diligence expected to extend? And being a ship owner yourself, how do you look at that, Amanda?
Well, I think the one thing that they could have done that they didn't do is just ask for confirmation from the master at the time that the update was sent that it had been recorded. I think that's the easiest way of having being able to show that the due diligence did go to extending to check that the master had had implemented the changes. That obviously wasn't the case here. And while it does look, when you read the judgment, that, well, the owners provided all of the materials and the tools for the crew to use, and the owner himself was, or the owners themselves were obviously quite put out at that additional step. If you look at it slightly differently and say you take a different principle, but with a similar concept, which is vicarious liability. Usually an employer is liable for the actions of their employee. So I think that while the owner in their mind had done everything that they could, there was more that they could do. And as the judgment highlights again, and as is well known, seaworthiness is a non-delegable obligation. You can't push that obligation as an owner onto another party. It is overall your responsibility. Obviously, as the judgment highlights, had this possibly happened during the transit and there'd been a change during the transit, then there might have been an areas of navigation defense, but this was before the commencement of the voyage. So there were additional steps that could have been taken. Yes, they do sound like they would have, like it would have been an added extra effort, but just getting a confirmation at the time and a follow-up just to confirm that the amendments to the charts have been made could have probably solved it. But there are ways around, or just because you've got the non-delegable duty there as a ship owner. There are ways of mitigating that. So you can do that through having through introducing new clauses. So I'm not sure whether we want to also go on to some of the questions we had been discussing previously, Jagmeet, or
yeah, that's fine.
okay. So
basically, so the main point that you said was that the obligation to keep the vessel seaworthy, especially beginning of the voyage, it's not delegable. You cannot basically give it to, you cannot blame the crew or the agents or ship manager, whatever, whosoever agent may be. So that's a fantastic point. Now, one more question, which is I'm going to ask Jay on this one, that this is anonymous, did 92% of the cargo owners already pay the GA contribution to the owners? If yes, will there be any recoveries? Jay.
Okay, so that's an interesting question. And actually, as far as we are aware, we don't know for absolute certain because we were only representing those 8%, but as far as we are aware, the rest of the cargo either paid 100% of the claim, or many of them settled for 98.5%. And I mean, Michael will probably be able to add another perspective to this. As far as we're aware, I don't think anyone is planning to or pursuing a recovery of those sums.
I see. All right. So again, I'm going to follow up on this one. Not exactly this part, but I'm going to ask you, should this case have gone to Supreme Court at all? And I would like my other lawyers to follow after you with their opinion.
Okay, so would you like me to get the ball rolling on that?
Yes.
Okay, thank you. So should it have gone to the Supreme Court at all? Well, I suppose where we're sitting today, we at least have the benefit of an unarguable decision, which is very clear and very helpful, as Amanda has been setting out all the principles for the application of the Hague Rules. From my biased perspective, I would say probably not, because we already had a good decision in the first instance and there was no need to go through the Court of Appeal and Supreme Court. But that said, it's been an interesting voyage.
Okay. Mikhail? Coming from the other side?
Obviously biased as well, but just taking a step back, I had the joy, it was on the whole a joy, to be a judicial assistant at the Supreme Court for a year back when I started practice. And the test that is applied is that the case has to raise an arguable point. The point has to be a point of general public importance, and it has to be a point that the court should consider at that time. Now, arguable, which is in theory the first sort of threshold, is extremely low as a threshold, right? Because barristers aren't even meant to run unarguable points. And it is much lower than the threshold that one needs for a first appeal, where your prospects have to be simply more than fanciful. So the real point of tension in all permission to appeal applications is whether the point of law is one of general public importance. Now, it seems to me that it is difficult to imagine points that are of wider importance to the shipping market and the common law more generally than the principles of unseaworthiness and due diligence. There have, of course, been some judgments on it, but not for a good 50, 60 years, if not 100 years, insofar as seaworthiness was concerned. So it plainly met the threshold. And I think one of the really interesting things is that the Supreme Court doesn't necessarily take cases where it thinks that established principles have been wrongly applied. The US Supreme Court often says of themselves that they're not a court of error correction. The UK Supreme Court doesn't put it in that way, but effectively that's the point. If the legal principle is well established, the fact that a court of appeal got it wrong doesn't get you an appeal, which sometimes I think people underestimate. What does get you an appeal if you are trying to reformulate, or at least asking the court to reformulate and grapple with, again, the underlying legal principles. This was plainly a case where that is what the owners were arguing for. They did ask for a reassessment of what Jay does quite rightly say were relatively established rules, albeit in a novel context. So therefore, in my view, the answer is yes, and the court should have granted permission to appeal. And the fact that the court in the end found against the owners doesn't in any way undermine that, because that's not the point of the court.
Okay, Edward or anyone, Clive, would like to give?
Okay, just very few points. I think taking as a neutral position. Well, apparently that those Lord Justice and laws agreed it was necessary to give the permission to appeal, right? Otherwise, that the Supreme Court would not hear the party submissions. And of course, I think from one point, I agree. The Supreme Court didn't, well, they only restated a number of well-established legal principles, which have already been widely accepted and, I think familiar to everyone, at least here, like the lawyers, ship owners, cargo insurance, and arbitrators. So from that perspective, probably I think it's not necessary to have the permission to appeal, especially that both the trial judge and the Lord Justice in the Court of Appeal are all very experienced shipping lawyers when they were in private practice. But on the other hand, of course, definitely the Supreme Court also gave a handful useful guidance on a number of important issues in the area of seaworthiness, which I think in the past decades, it was very rare to see such kind of case went to the highest court. So I think, especially taking into account, in the past decades, the technology have improved a lot. So I think it is a good, at least as a reminder for or clarification from the highest court to provide this kind of guidance to everyone. So I only add these few points. Yeah, thank you.
Jagmeet, could I just ask a question of Jai and Michael, who were both intimately involved in this? If the owner's instructions to masters had said in clear terms that on entering and leaving harbour, stay within the fairway and do not leave the marked channel, what effect might that have had?
Michael, do you want to go first on this?
I can go first. I feel like Jay has had to bear the brunt of going first, so I think it's my turn now. I think that's a really interesting question, Mike, because one of the really strange facets of this case was that if the master had simply followed his own passage plan, which would never have taken him out of the fairway, the grounding wouldn't have occurred. He made this decision to leave the fairway in circumstances where the judge at first instance held that he would not have done so had there been a warning on the top of the passage plan saying some depths are less than charted outside of the fairway. Now, I wasn't there at first instance, but that just seems a bit implausible, doesn't it? I mean, if you're making this decision, the fact that some warning is going to be around there and you're going to check the passage plan for that warning, I don't know, maybe. If, however, what had happened is that everything was the same, so there was a passage plan which didn't take the master out of the fairway. One of the reasons why the passage plan was such was because, say, the master was following an instruction not to leave the fairway when you go out to the port, which in any event is standard practice. And he then nevertheless left the fairway, then I think we might have a sort of causation argument where the real question would perhaps be, well, if the master was ignoring instructions not to leave the fairway, was it really the passage plan that was causative of it? If Mr. Justice Tay had nevertheless held yes, the lack of warning in and of itself was a cause of him leaving the fairway, putting to one side the fact that doing so would have put him in breach of the explicit instruction, I think the outcome would have been the same. And I think this probably goes back to what one of the questions was, which was, well, what more can owners do? And as Amanda says, a bit, perhaps not much, but maybe that's all right. I mean, in the end, one of the really interesting facets of the Supreme Court case was that, as far as I'm aware, was the first judicial grappling with the insurance implications of how this all works. And at the end of the day, if you're happy for risk to be allocated from cargo to carrier, and you're also happy to pay the higher freight rates that involves because carriers have to get more expensive insurance, then so long as there is no double insurance, i.e. cargo isn't independently of that also still insured for that risk, the price for the end consumer should remain the same. Cargo pay less for their own insurance, they pay more for freight, and carriers pay more for insurance, but they get more freight. The consumer should, in theory, be no worse off. So you might say, well, if we have a perfectly efficient insurance market, it isn't going to make any difference to prices. What might happen, on the other hand, is that freight rates go up, but the price of insurance for cargo doesn't go down, and actually the consumer ends up paying more money at the end of the day because freight is more expensive, but insurance, at least for the cargo side, doesn't get cheaper. So it is a tension, and I think that the only way to find out how it's going to evolve is to wait and see, really.
That's a great point, and thanks, Mike, for a fantastic question. Jay.
So there's quite a lot to talk about there, but I think I'll try to summarize in just a couple of short points. At least I intend them to be short. Whether they end up being short is another question. So first of all, if the master had got instructions to stay within the fairway and he went out of the fairway, that question. So actually one of the things to bear in mind in this particular case was all the parties agreed this was an error of navigation. Okay, that's something to bear in mind. So you might explain the debate in another way. You might say, were sufficient steps taken to reduce or minimize or eliminate the risk of an error of navigation? So it seems to me, and I'm not a seafarer, it's a much too dangerous job for me, but it seems to me obvious that you should stay in the fairway. You know, I tend to drive my car on similar principles. But I think the point is that the passage planning, the preparation should be aimed at reducing the scope for errors. So there was talk in this case, for example, about no-go areas being marked. And if you look at it, that boils down to some degree at least, to basically marking the areas out of the fairway as no-go areas, more or less. And that makes sense because this is a 400-meter long vessel with, I can't remember, 15, 20 meters draft. You know, you don't veer off just for a bit of entertainment, at least not unless you're a lawyer. So the way I would try to explain it is that it's just a question of risk management and reducing the probability of risk. And also, so you've got a plan of action if something unexpected happens, okay? Because at that point, you know, the moment of agony, you don't want to be starting your planning then. Just to mention another point for general interest, actually, I wonder, and maybe Amanda will comment on this later, I wonder about the role of audits, because actually, in terms of the passage plan on this case, there were a number of passage plans that were similarly defective for previous voyages. And I think something that we would be looking at in a future case is, you know, what the audit trail was. I mean, as Amanda said, if you send off the passage plan before each voyage, then that probably makes the audit academic because you've done it then. And if it's defective, it's defective, and if it's not, it's not. And again, as Amanda rightly said, it's a non-delegable duty in the same way as a ship owner would be responsible for a deficient repair done by a third party. And then the last of my rather rambling summary is to touch on the insurance question, which was mentioned. Will it result in an allocation of risk changing? And I think yes, to a small extent. I mean, you've got to remember that the premiums taken by the cargo market run into, I can't remember, 50 or 60 or 70 billion dollars a year. And the international group of P&I clubs attempted to intervene in the Supreme Court, and they said they had about $116 million, I think, roughly of that order, of existing cases that this decision affected. And you can probably guess that they were spread over a few years, because cases like this don't resolve in 1 year. So it might make, well, all of these things will make a slight change in the allocation of risk and the slight impact on P&L for cargo insurance and P&I. After every case, you know, you see the insurance premium charge and you think, my goodness, that's peanuts. It really is. So I don't think it will really make much difference to the end user. And actually, theoretically, and I'm a fan of P&I system, by the way, having started my career there, P&I insurance is supposed to be mutual and at cost, right? And cargo insurance is supposed to be for profit. So if there is a shift towards P&I, then perhaps theoretically that will end in a tiny, tiny, tiny reduction for the end user. And that's my, I don't know, 5 or 6 minute summary.
Thanks, Jay. Anyone else? Amanda, would you have any comments on this one?
Yeah, so in terms of having an audit trail, I don't actually see how an additional check like that would actually cause that much additional work. Thinking about it, how we run operations internally, when voyage instructions go out, there would be a confirmation coming back from the master that those have been received. As the master isn't acting in isolation, there's an ops team in head office always. So it should be the role of a good ops manager to be able to look over documents and also understand what's going on. So having that extra line, I don't see how having that extra level of checking would really effectively add that much additional work on a day-to-day basis. It would also not necessarily, it wouldn't add a lot of time. It wouldn't really add a lot of effort either, especially now that most passage planning is done electronically. It's not like there is a hindrance in terms of the vessel being able to send back a copy of their passage plan. So I don't foresee how, yes, it's an extra added step in the day for the crew on board, which as in my introduction was kind of my main bugbear about the decision. Not that the decision was wrong, but that this will add work, but we are stuck with the decision. So you might as well make the best of it and find a way in which to protect yourself from it, or protect yourself from the potential impact thereof. But yeah.
Thanks, Amanda. Edward, then followed by Mike. Because this is a very, very important and very good question, which Mike had asked. Edward, any views? Any comments?
Honestly, I don't have any additional comments. I think that's already very comprehensive from the others.
That's right. Mike, anything from you? What made it, this question is so good, is something that you can add on to it?
All I would say is that things can happen very quickly on a bridge at sea. And whether, I believe that part of the problem was that the soundings information wasn't marked on the chart. But whether or not a master having to make a prompt decision would go back to the chart table to have a look at what was on the chart, or simply react to what was happening in front of him, I would question. And and this is no criticism of the judiciary, but whilst they have undoubted knowledge in shipping law, when it comes to practical experience, even just a feel for the size of the bridges of these ships, where things are laid out, etc., and particularly navigating at night, to be there is very different from looking at it in the cold, hard light of a courtroom. But as I say, that is not a criticism. It's simply an observation. And I think the last member of the judiciary that I can recall who had any seagoing experience was Lord Phillips, who did his national service back in the Royal Naval Reserve back in the 1960s. But that was a very, 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 very long time ago. But I will say no more.
All right, thank you, Mike. I think this is such an important question. I must ask everyone about this, that did their lordships got it wrong or got it right rather? They're totally out of touch, as Mike said, though it's not a criticism. Again, I would also like to clarify that, but out of touch with the realities of the shipping markets or ships.
I don't think they necessarily got the decision wrong in terms of the law, but I don't think they've necessarily, I don't think they necessarily appreciate the impact or how commercial shipping actually works. It's often seen even, well, in pretty much every decision, especially also like when construction points are raised and people talk about the intention of the parties at the time the contract was entered into. Well, quite often in especially in a fast-paced commercial environment, I can guarantee you that the chartering managers aren't sitting there reading every single term of every single charter party they're going through, especially if it's for a single trip or a short voyage. They're just going like, okay, well, we've done this on this term before, or on this pro forma before, it's been fine. We'll just go with the same. And then a new issue arises, and that's where the construction point comes up. But I think it's hard. We can't be too harsh on their lordships in terms of being a little bit out of touch. They're not the youngest. They also, it's not in their realm of expertise. As Mike has said, we don't have a current member of the Supreme Court who has been to sea, and certainly not anyone who's been to sea on board a modern commercial vessel. So I do think that it's maybe a little bit difficult for the court to fully appreciate the actual commercial workings when also possibly some of the experts involved necessarily don't have the newest experience. So I think we can't be too harsh on them, but I do think it is a little bit out of touch in terms of how things work. I also think that, or personally think that potentially the court, it would have never got to the Supreme Court if at first instance the reasoning for leaving the fairway had been made clearer. For example, if there was an emergency situation that wherein to save life or to avoid a collision, the master had no option but to leave the fairway, then I think he would have been safe from an errors of navigation defense, because it wouldn't have been down to what the passage plan said, because what was in front of him was more pressing. But we are where we are. So.
All right, thanks. Michael, then I'll move on to my other two lawyers here for their opinion.
Always find it difficult to comment on cases in which you've been involved in, because you either look like a sore loser or you sort of give away the fact that you didn't believe in your case. So I think on the Supreme Court decision, I just won't comment at all, but I will say something about the first instance decision, which luckily I wasn't involved in any way, and therefore I have the requisite critical distance from it, which I think is just tying together perhaps what Amanda and Mike just said, which is there is all sorts of reasons why you might want to leave the fairway and have to do it in an emergency situation. And also, I think someone in the chat mentioned it, that, you know, there might be other vessels obstructing you, like fishing vessels, and you might just have to leave the fairway. In those cases, it seems to be inherently unlikely that some warning on top of the passage plan is going to make any difference to you. And if that is right, well, we would never have had this case, because the vessel might not have been seaworthy, but it wouldn't have been causatively, it wouldn't have caused a casualty. And I think that's one of the things to keep in mind, is that vessels can be unseaworthy in all sorts of ways all the time, in the sense that there is some sort of defect which a prudent owner would fix if the prudent owner knew about it. In the vast majority of cases, the fact that vessels are unseaworthy doesn't cause casualties, though, so it's totally relevant. It is only when the unseaworthiness actually is causative that we all end up in these court proceedings and have to look at the issues in the harsh, cold light of, you know, either the roles building or an arbitration suite. So, I mean, that's perhaps one of the perhaps that allays some concerns on the carrier owner side about the real implications of this. It might not actually make much of a difference, and the reason it made such a difference was because of the findings of Mr. Justice Tier, which, of course, everyone else had to take as read, and we couldn't overturn. And maybe that's the real point on which reasonable minds can disagree about the rightness and wrongness of the decision.
Right. Thanks, Mikhail. I think you touched upon a very important point in terms of seriousness and whether that was the cause and how the court looked at it. So, Jay, in addition to answering my first question, so if you can also add on to this part in terms of there could be a number of defects, but they can be remedied, right? So, how does that link with this particular decision? Is it something that could have been remedied just by sticking to the fairway?
Well, I think, yeah, first of all, it's probably better that I don't say whether they got it right or not. My answer is going to be entirely predictable. And I think that the point that Michael mentioned about unseaworthiness is quite right and quite fair, that, you know, even the best ships are unseaworthy in some way, shape or form. You know, it's a huge, complex thing, trying to do a difficult job. I don't imagine it's the case that any ship, even a new one, will probably be perfectly seaworthy in all respects. But the thing we're all interested in is whether it makes any difference, so whether it was a cause. And that's really the focus of all of our disputes, whether it made any difference, whether it's causative. So I think that's probably what I would say about that.
Thanks, Jay. Edward, Mike, anything? Amanda, would you like to add to that further? No? Okay. Mike, you want to add? No? Okay. So what we do now is, I think we have come quite close to our part. And before I go to the closing statements, we got a number of questions. 2 of them we answered from the Q&A. So we'll have about 13-14 minutes to do that. So just 1 minute each, if you want to. You started with your opening statement, then we had this discussion. Anything that your key takeaways for the participants or the audience here, starting with Jay.
That gives me a couple of seconds to think of something to say for a minute, I suppose. Well, I just think the general point that was mentioned, I think by Amanda, that this is a nice recap of how the Hague Rules should be interpreted and how they should be applied. That is probably the most widely useful general point, probably for anyone. It's a good place to start if you wish to review how they should be applied in practice. I think that would be what I would say.
All right, Amanda.
I think similar. So I think the best takeaway from the judgment itself is just the guidance that it gives on the general principles. I think you need to pay attention to whether causatively it's actually going to be applicable in your situation, but also just to view it from an owner. This doesn't necessarily make it mean that the entire burden ends up lying on you. There are means by which you can not delegate the due diligence obligation, but mitigate the impact thereof. So deck cargo clauses, for example, under English law, you would be transferring the liability for loss or damage due when there's a howsoever arising, to effectively exclude the effect of liability of a carrier's negligence or its failure for due diligence to make it seaworthy, and pushing it onto your charterers. There are other clauses you could attempt to put in. How effective those clauses would obviously be dependent upon how they're drafted and are yet to be tested. But there are ways that you can mitigate your actual exposure, be it on your P&I loss record or your bottom line.
Yeah, and market permitting, MP, yeah, weather permitting, market permitting. So of course, that's very important. Anybody else commenting on that? Mikkel, Edward, Mike, one minute each. Your key takeaways.
Okay. Sorry.
No,
Michael,
please, Edward, go ahead. Edward, go ahead.
Yeah, very short. I think, as I said, that ship owners have the concerns that it tends to the scope of this, those obligations, beyond what is practical, and expose them to claims that are actually, I think, from owners' perspective, traditionally can be avoided, as we discussed, whether those lost ships were wrong or not, and whether they do not have the sea going experience or not. That is the decision made by the Supreme Court. So it certainly underlines, I think, the need, and I agree with the other comments from the panel members, that for the ship owners to ensure that a vessel's charters are kept updated, which nowadays is more, I think it's much easier because everything is now electronically updated, and that careful passage planning to be undertaken by the master and the second officer. It's not, I think, an increased burden on the ship owners because they are supposed to do it. And I think the case just serves as a reminder that they do need to pay attention to the passage planning. And of course, on the other hand, it's likely to encourage cargo owners and insurers to take a more robust approach to claims for general average contributions, which I think that we can keep an eye on to look at it. Well, one further issue that actually I think when we were preparing this discussion, that I was asked about the remediable defect. I think that the fact that a defect is remediable may also mean, I think from my reading of the Supreme Court's judgment, is that a vessel is not unseaworthy. This, however, is likely to depend on whether it would be reasonable to expect that the defect is remedied before any danger or risk to the vessel or cargo when the risk arise, so that the defect need to be remedied before the risk arise. But on the other hand, I appreciate that if the risk does not arise, probably even the ship owner do not realize that actually there's a defect in the vessel. So yeah, so that's my point. Thank you.
Thanks, Edward. Mikkel?
Key takeaway on the legal side, I completely agree with what Amanda and Jay were saying. Indeed, I think I said it in my opening, so at risk of repeating myself, I think this is the perfect place to start if you are ever confronted with a Hague Rules issue. It tells you what the rules are and where to find further reading. The key practical takeaway, perhaps for cargo, well, less cargo perhaps for carriers everywhere, is in the new age of liner services, most of these vessels, go up and down the same way over and over again. And as I understand it, and I think somebody's mentioned this in the chat, there are now ship owners who just send out passage plans to the vessels, basically have the master sign them, they can add some stuff, but they're basically pre-filled in things, and it becomes a bit of a tick box checking exercise, which isn't necessarily what the point was. One of the points of the judgment was that it was felt that this was such an important feature of ensuring safety at sea that it should become part of the seaworthiness obligation. So to what extent that's actually going to be achieved by the judgment, I think remains to be seen. But I understand that some ship owners have taken the defensive step of simply sending out the passage plans, knowing that the ones that they send out are probably all right. And then if there is a mistake that is made, at the very least, it's not the passage plan's fault.
Yep, thanks, Mikhail. I mean, it might look one of the things that you have to do because a decision has been given like that, but there are hundreds of other things. And if we have to start doing it and take away what the crew should be doing on board and take the entire load on yourself in the office, I think that could be an issue. So I'll go back to Mike, as he mentioned about training in his opening statement. I think that continuing training is the one of the most important things. Mike.
Thank you, Jagmeet. I think we all have a rather jaundiced view of the shipping business because we only see the things that go wrong. We don't see the millions and millions of voyages that are successfully completed. So I think as far as world trade is concerned, there doesn't need to be any concern about this case. We will continue with the shipping business providing the needs of the world. So far as future incidents are concerned, I'm sure that that cargo interests will take great succor from this particular decision, and I think that ship owners can expect wide-ranging disclosure requests from cargo interests. That in itself is nothing new. We're all used to cargo interests asking in days gone by for every single document that they could possibly get their hands on to see if they could find something. But here, their enthusiasm will be redoubled, and ship owners will need to prepare for that. And just on electronic charts, I mean, there's almost a feeling that it's okay now. It's all it's electronic charts. I don't think that they provide a lot of answers. They're not the complete answer. You know, by way of small example, about 14 years ago, the US Navy removed all sextants from their ships. They have recently put them back again, because if the electronic chart doesn't work, how do you know where you are? And if you haven't got a sextant, you don't. Now, I don't think that necessarily has any relationship to these sorts of cases where this is inland navigation, but it just gives a feel for how we should not rely 100% on the bits of kit. That basic seamanship is absolutely essential, and maintaining the standard and the training, and owners being confident that their crews are properly trained, I believe is critical.
Yep. Thank you, sir. Thank you very much. Now let's come to the question box. Some of them we already addressed. I'm going to look for the shortest, and all of them are very interesting. And let me assure the participants that the questions we are not able to answer today, we'll have the panelists answer those, and we are going to send these to you. On the 8th December, we had the general average webinar. The answers are ready, and we are going to circulate to the people who have asked unless others also would like to have the answers. Okay, I have a question here. I think this anyone can answer, not someone specific. From Silvia Cabrera Rosando. Will deviating from the passage plan seem as a presumption of unseaworthiness despite the reality seafarers find in the day-to-day sailing? I think it's a quite an important one. Amanda, I think from the practical perspective, what do you think?
I don't think it automatically will, no. As we've discussed at length, it's also a causation point. So deviating from a passage plan doesn't render a vessel unseaworthy. It's a defect with that passage plan to begin with. If there isn't a defect with that passage plan, then that point doesn't even come up. And therefore the deviation from the passage plan is more of a navigational issue. And then you have your errors of navigation defense if it was the wrong decision.
Right, thanks. I think this one again is for you, Amanda, because again, quite practical regarding off-hire and things like that. This is from Sanjeev Verma, who is one of our executive committee members of the ICS Hong Kong. Referring to this case, can the master deny sailing out of the port till he is fully satisfied that a proper passage plan is in place, considering rest hours of his officers, and she will not be off-hired by the charterers?
Well, firstly, I think that you're never going to get that situation arising, mainly because an owner won't allow it to arise because they don't want the risk of their of an off-hire claim arising. Whether that scenario would fall under a normal off-hire clause depends on what's been done to the off-hire clause, but then there is a argument that if it's got the if it extends to the actions of the officers and crew, that it is an automatic off-hire event, because off-hire is a no-fault provision, so you wouldn't really have to prove much more rather than the that you're losing time because of a listed off-hire event. So while it's a nice theoretical question, I think you're more likely to see masters taking a stance when it comes to the rest hours of their crew and what their crew are going through, as opposed to the passage plan delaying things. And as we've already had, there are scenarios where those passage plans are prepared on shore and just sent aboard. So I don't think it's as much of a potential issue. I think it's a nice theoretical one. So if someone wants to write a thesis on it, it's an ideal question for a law student.
All right. Anyone else? Anyone would like to add on to that? Say something? Yeah, Edward?
Just a few sentences. I think I agree with Amanda. You know, it's very interesting if we see this in a real case scenario, because if I'm right, you know, it is for the master to prepare the passage plan, and obviously, you know, on one side, if he's not satisfied with his own plan, then he needs to rectify it, and if he's for whatever reason cannot rectify it, that means probably the master and the other senior officers on board are not competent, and which constitute unseaworthiness of the vessel. So I do agree, you know, what Amanda said, you know, it will not happen in the reality. I'm not sure if Sanjeev have ever seen such kind of issues in real life. You know, that will be very interesting to know.
All right. So this is the thanks a lot, Edward. So this is the last question here, and anyone can answer that. And after that, I'm going to request our session chairman to basically give his views, just conclude this webinar, and also, you know, like tell us a few things. Ritesh Kaushik, this is a question which he has asked. In a similar scenario from vessel's engine room, all right, I think Mike, you should be able to take this one. In a similar scenario from vessel's engine room, for example, if a maintenance is carried out in port and the chief engineer could not follow the maker's latest guidance circular. Now, not the manual, this is the guidance circular with some changes possibly for maintenance, which was supplied to the owner's office, but was not connected to the vessel in time before departure. Does it fall under owner's due diligence? Is he liable after this judgment? And then his second part is, or if the circular was received on board, but was not followed during maintenance. Let's start with Mike, and then somebody else can fill in. Mike.
Well, that's a fast ball, isn't it?
Totally, I think.
I think one should bear in mind that if you ask for free advice, you get what you pay for. I think I would really want to think about that a little more. I mean, it does raise important issues, but I would be loath to give an off the cuff answer to that. I know that's dodging the question, but it's you know, there's a big audience here, and
so
I would need to think about that.
What we can do, Mike, is we will take this question into consideration amongst other questions which have been asked, and we will get back to the audience with the answer after giving it a due thought. Is that fair? Also, in the interest of time.
Yes, but I'd want to see and think about it. And it may actually be quite a difficult thing to answer. I mean, I'm not saying that once I've seen it, I'll answer it.
Okay. All right. I would like to thank the panelists and pass on the baton to Mr. Clive Aston, who is the past president of London Maritime Arbitrators Association. Clive, please.
Thank you, Jagmeet. And I must congratulate you as one of the organizers of today's event for picking a topic that obviously it touches a lot of people's hearts, and also for attracting such a distinguished audience. Now, on this occasion, I've been able to sit back and watch other people speaking, but it has been fascinating and really quite educational for me, but also to look through the list of the people who've been watching. It's a very distinguished audience, and I think that's reflected in some of the very pertinent questions and points that have been raised during the course of this webinar. You asked the question, did the Supreme Court get it right? Well, whether or not they did, it reflects the law as it now stands, and we have to live with it. And quite often after a landmark decision like this, one is talking about, well, you can always negotiate a clause to get around the decision. And I see that this was one of the questions that was raised during the webinar. What will these clauses be and what will they say? And I think also interestingly, will they be clauses that practically would be acceptable to any charterer of a ship or any cargo interest? It's often very hard to draft a clause that achieves what you want. The best one can often hope to do is achieve a little bit of a fudge and leave yourself some wriggle room when it comes to a dispute. I think, what do I take away from this? I take away from this the fact that this is clearly a topic on which there are very strong and divided views within both the legal profession, but also the industry. And what are those divided views? Well, the allocation of risk between ship and cargo, the allocation, and I think this is an important issue, the allocation of responsibility between ship and management office. And I think that is something that we will have to look at in some detail in the future. And I think also the point that Mike raised of the distinction between theory and practice. What is clear is the concept of unseaworthiness, rather like perhaps remoteness in the field of damages, is constantly evolving. under the common law. And so, you know, we have a stepping stone decision here with the Libra, but there are going to continue to be developments and modifications, if you like, of the law. There are always going to be slightly different factual scenarios that we're going to have to deal with. But what is also clear to me is that for an owner's point of view, the bar is continuously being raised. More is always expected of an owner. The internet creates greater knowledge. We now have far greater communication. And so the burden upon those undertaking responsibilities becomes greater. The expectation of what they have to do becomes greater. And from an industry point of view, we have to view this against a background of an industry where we're finding it more and more difficult, not only with COVID, but generally, to attract seafarers, to make the industry more attractive and popular for seafarers. And you know, it is a little bit of an irony that the burden is being raised and making it harder for people to get into the industry just at a time when we have critical shortages. So I think we take away a lot from this webinar. But as well as thanking you, Jagmeet, I must also thank the speakers today. A testament to how entertaining and how informative a talk is looking at the number of participants. And although now it's slightly lower, the numbers have only really gone down when I started speaking. So the speakers themselves maintained interest throughout, and I found it utterly entertaining, and I think the audience did. And I would thank those who've participated, because this has certainly been a webinar where they have contributed. The questions, the point raised, have been excellent. And so, you know, I think we will walk away with this with greater knowledge and perhaps food for thought. Finally, just a word of thanks to all of the organizers. As Puneet said at the beginning, this has been an international collaboration. It's been a collaboration between opponents, the two opposing legal teams for the parties, but also for the leading maritime arbitration centers. London, Singapore, Hong Kong, and that is always good to see. So really, a thank you to everybody concerned, and also to the organisers, the Chartered Institute of Shipbrokers, India Maritime University, HKMA, CMA and LMAA. But I know it's late in the day now for many people watching, so a real vote of thanks also to everyone who stayed this late. And we look forward to the next webinar.
Thank you very much, Clive. And since you talked about the next webinar, we haven't thought about a topic, and this is something I'm going to leave it with the audience today. If they think there is something which is of interest to them, they can just drop us an email at chairman@ics.org.hk. We'll really appreciate, and possibly we can put things together with such fantastic collaboration again. Thank you so much. Thank you, Clive. Thank you all the panelists and everyone. And good night, and have a good day.
Thank you, everybody.
Thanks a lot.
Thank you.
Thanks very much.
Thanks, Puneet. Thank you so much.